Okay, I think we should be live now.
We're live. Okay. Well, welcome everybody to this week's edition of our Facebook Live from Joseph and Hall. I'm Aaron Hall. I'm joined today by Rylan Warner and Jennifer Howard. And as always, we'll be each giving a brief update on something in the world of immigration. And then we will try to get through some of your questions. With that, let's get to it. Rylan, do you want to start by giving your update?
Sure, yeah. So it was kind of a news story this week of a senior State Department official named Harold Koh. He resigned from the Biden administration, but upon his resignation, he put this letter out into the world saying that he was really disappointed with the Biden administration's continued use of Title 42 that was initially started under the Trump administration, but the Biden administration has continued using it. So Title 42 is it's meant to prevent the spread of communicable diseases into the United States, and it's power by the executive branch that wasn't really used to prevent refugees or asylees entering the country until March of 2020. Until that's when it started being used against anybody that was trying to come into the country as basically just this arbitrary defense saying, "Hey, we cannot deal with the spread of COVID. You might have a legitimate asylum claim, but we're not going to listen to it." And so it has been continued to be used since the Trump administration into the Biden administration, and that's what Harold Koh is complaining about, and rightfully so, because under the Convention Against Torture and the refugee protocol, we should be listening to people's asylum claims and not returning them to their countries where they have these legitimate claims of fear persecution. But that's what we're doing, and what Harold Koh is mostly concerned about is how we're implementing this still against asylum seekers from Haiti, which, as you might know from the latest news, Haiti has undergone a lot of stuff with the assassination of the president, with earthquakes, with gangs, and what was already a vulnerable situation has just been made worse. And now the Biden administration is continuing to use Title 42 to just ship people back to Haiti, even though it might be a violation of the Convention Against Torture, which says that we shouldn't be putting these people back into Haiti where they could face legitimate claims of persecution. And so it was something that I liked reading. I was glad to see someone that was part of the administration, even though they were now stepping down, speaking out against this practice. And I hope that that more government officials begin speaking in this way and start saying, "Hey, we should not be using this power of Title 42 to put people back into danger. That we need to hold off on that sort of practice and try to help people, especially when not doing so violates these treaties and agreements that we have agreed to uphold. So yeah, that was my update for this week. Not much of news, but just a little snippet.
It was really good to see somebody going out noisily like that and calling them out for continuing this like fever dream of Trump and Stephen Miller into the Biden administration. It's been wild to watch.
Yeah.
Okay, Jennifer, how about yours?
Sure. So mine's just a quick update on something I didn't even really know much about until this week, but the Office of Refugee Resettlement just announced that they are going to increase the payment ceilings for refugee cash assistance payments. So for a little bit of background on this, when the ceiling was established back in March of 2000, the Office of Refugee Resettlement, or ORR, used the 1998 HHS poverty guidelines and established it at 50% of those guidelines for each family size, and then its monthly payments, so divided by 12 months. And for a household size of more than 4 people, you would get $70 more per person per month. And so that hasn't been updated in 21 and a half years. And so now they're going to be using the 2021 guidelines instead of the 1998, which obviously has gone up for inflation. And then families of more than 4 people will now get $113 per person per month additional instead of $70. So it's been adjusted. This does only apply to people who are recipients of the refugee cash assistance through the public-private partnership program. And so it depends on the state where you live. And I'm sure if you are getting these payments, then you know what your state uses. But yeah, it's kind of exciting that, you know, it's been 21 years that they haven't been adjusted, and now they finally realized, you know, with inflation that people can't afford to live on what they've been getting.
Yeah, I didn't know that either. Interesting. And then my update is not really news. It's just about the implementation of a program that was in the news a few months back. It's about U visas. So U visas are visas for people with who are victims of certain crimes who have been helpful to law enforcement in getting the crime investigated or the charges prosecuted against the offender. And the big problem with U visas is that Congress only allotted 10,000 per year, and there are many more applicants than that. And so there's formed a backlog that they now take many years to adjudicate. I think right now, if you file a U visa today, you might be looking at 10 to 15 years until you actually get a U visa, assuming it's approvable. And so recognizing this problem, the Biden administration actually put into place a new process that allows people to get some protections from deportation in the interim. And the process that they put into effect is an improvement on some other processes that had existed before, but it's called a bona fide determination. So basically, the idea is that when they get a U visa application, they are looking through and trying to see if it's approvable and if it looks like a case that they would want to exercise their discretion in approving in the future, even though they can't approve it for now. And if it is, they send a letter that says you have a bona fide determination and you're eligible for work authorization, and you are placed into deferred action, meaning that immigration authorities are not going to be trying to deport you. Like I said, this program actually got put into place months back, but we hadn't seen, at least to my knowledge, we hadn't seen in our office anybody benefiting from it. And this week, our clients got a bona fide determination, and it gave him a work permit that's good for 4 years, and he can extend it when that's done. And it's going to allow that client to seek to close removal proceedings against him. So it's nice to see. Hopefully, that program is coming online, and more people who are just waiting for their U visas are going to get these letters that give them some protection and work authorization while they're waiting for these long backlogs to go through. So I think that's it for the updates. Let's try to get through some questions. Raylan, you have control over scrolling.
I do. Right. So we got this first question from Elon. He says he's a K1 Moscow. And they were hoping that this would all be resolved by fall, but it seems like none of the K1 lawsuits are moving. Do we still anticipate that they would get the visas this year?
Well, I hope so. And Rylan and Jennifer, please add into this. But basically, the status of the K1 lawsuits is this. The government filed motions to dismiss, and we briefed our responses to those. And the motions to dismiss are fully briefed in each of those cases. What happens next is a judge is going to make a decision about whether the lawsuit should be dismissed or whether it can continue. We think that the motion or the briefing that we did against the motion to dismiss is strong, and we therefore think that it's likely that the court will rule against the government's motion to throw out the case. But until they do that, the government isn't feeling much pressure to push through cases. Now, if they deny the motion to dismiss, like we expect, at that point, a lot of times the government says, well, rather than further litigate this because the court has already ruled against us on one issue, why don't we just see if we can moot out most or all of the plaintiffs by processing their visa applications? And so oftentimes, shortly after a motion to dismiss is decided, if it's in our favor, that's when we'll get to see a lot of movement. Unfortunately, we have control over when the court makes a ruling on these motions to dismiss. It could be any day. We would expect it would be soon. They've been pending for quite a while, but we can't control it. Do we still anticipate that people could get visas this year? Yes, I still think that that's reasonable, but we just can't promise it because it's in the hands of the court. I see 2 questions down. The same person, Elon, asked about a comment from Charles Cook the other day, saying that there were now 5 officers working in the Moscow embassy in the processing visas rather than 1. I'm sure that Chuck got that information from a reputable source to repeat it, but I don't know what it is. I don't have it, so I don't have the source for you there.
Okay. Ronald is asking how many documentarily qualified plaintiffs are in Go. Chuck said 490, including derivatives. Do you know this, Aaron?
Yeah, if you can give me a second, I'm happy to pull up a document that should have that on it. Maybe you can move along and we can come back to that while I pull it up.
Okay, we've been talking a lot about the new vaccine requirements, and Elon says, per the CDC guidelines, K1s need to be vaccinated with a CDC or WHO approved vaccine in order to receive a visa, but those who don't have them routinely available are exempt. Russian citizens are exempt to get the visa. I would assume that he means the vaccine there. However, the new travel restrictions that will begin in November seem to target all non-citizens. My question is, how will this affect Russian K1 holders since they don't have approved vaccine available? Will they be exempt from this new rule? So for these new the new travel restrictions in November, targeting all non-citizens, I'm not sure what the requirements are there for the vaccine. I haven't looked into that quite yet. Aaron or Jennifer? Jennifer, I saw you shaking your head no that you weren't familiar with it either. Aaron, do you know anything about the new vaccine requirements that will be happening in November?
Yeah, I'm looking it up right now.
While Jennifer looks that up, my understanding without looking at it was that the vaccine requirement would be in place with an exemption or a waiver for people in places where the vaccine wasn't available.
Yeah, that's what it was for USCIS's requirement for the vaccine. Just like what Elon was saying there, that it was exempt for people that were in an area that they were unable to get it. I would assume the same exemption would come into place, but I don't know that for a fact. So, Aaron, were you able to find out the number of DQ plaintiffs in Go?
I will be. My computer is like doing that spinning thing where it says it's like trying to open a document, but it's not quite there yet.
I love the spins. Okay, well, I'll move on to Hani Drode, and they say in Go they sent their documents on March 19th, and they have not been documentary qualified yet. Is there any hope for them? March 19th?
Yes.
Yeah, I would think so.
Yeah, I wouldn't. I don't think it's fair that there's not hope for any Go plaintiff. There are, and again, I'm trying to pull up this sheet. I don't really know what's going on with it, but maybe I can find this in another place. there are going to be a significant number of the visas that were reserved by the judge that go to people who have not been documentarily qualified. That I can say for sure. And I'll get you a number of documentarily qualified people as soon as my computer decides it wants to open the spreadsheet.
Okay. I'll move on to Osama. They say they're very appreciative of Aaron and the team's efforts, but why are we not appealing Go? To have Judge Mehta increase the visas in Gomez after the fiscal year, we can't accept that when 70% of plaintiffs don't get their visas. So why are we not appealing it? I'm sure that we have discussed this in other Go videos before, but what was the rationale for not appealing it?
Well, I don't think that it's 100% set that it won't be appealed yet. But let's just, because if the government is going to appeal, then we would likely cross appeal and raise any issues that we wanted to, including the math that Judge Mehta used to determine the number of visas. That said, when you appeal, you can lose everything, and so it's not an easy decision. Why? You can easily get a panel on the DC Circuit that has two judges that read the statute to end availability on September 30th and say, I don't care what the judges say about all this equity junk. Courts don't have the power to override Congress and reserve visas past that deadline. Other judges have already said that. And I know of various judges on the DC Circuit who would likely say something similar. And so what could happen with an appeal, if we choose to bring the appeal, which otherwise wouldn't have been brought, is that all is lost. And so that's why it's not an easy decision to appeal. Now, the other comment was, we can't accept that this is a win when not every plaintiff is going to get their visas, and a significant number won't. And that's really upsetting to us too. We wanted every plaintiff to get an interview for a visa. That said, the reason that it's a win, at least in my eyes, is the reservation of visas based on us prevailing on basically every legal argument throughout the case is an extraordinary remedy. And it was ordered in Gomez. It was ordered in Go. It's been ordered in a couple of other cases. But it's really an extraordinary thing for a court to say, to extend a statutory deadline like that. And so, yeah, absolutely, it's a win, and it's especially a win, obviously, for the people who end up getting their visas through the registration. It's a win for people who got visas who would not, before the deadline, who may not otherwise have gotten visas if they had not gotten the pressure from the litigation and the early September order from Judge Mehta. So yeah, that's why in most respects it's a win. Is it the 100% win that we all wanted? No, it's not.
Michael asks if there's still a plan to add Manila plaintiffs to Ramirez if the motion to dismiss is survived. I know that we were talking about this. Zach was discussing this as a possibility. I assume that this is still the plan?
Yeah, and I think that's absolutely still the plan.
All right. Ronald is asking, can we please take a moment to share the total plaintiffs from Nepal? I'm sure that cycle is not helping you right
now. No, and I don't have that handy anyways. So no, I can't do that, Ronald. I'm sorry. So just so you know, I have the DQ numbers. Let's see. Of all plaintiffs, from the best data we have, 660 were documentarily qualified, including derivatives. And that that includes people who got visas. So there were 414 people who already received visas, meaning that about 246 plaintiffs were deemed documentarily qualified by National Visa Center, but have not yet had a visa issued. As you all know, the judge reserved 481 visas. So if you do the math, then about half of the visas that ultimately get issued this year will be to people who have not yet gotten notification that they were documentarily qualified. That is why I say it is not I don't think it's reasonable for anybody who hasn't been documentarily qualified to lose hope. There's definitely a chance. It's not a certainty or anything like that, but there's a chance that you'll have your visa processed and that you will get a visa issued. One more thing on the data. We have been working on this data this week. We are planning on emailing out a summary of some of the data to plaintiffs. So for data specific questions beyond kind of that thing that I was ready to say right now, I don't have answers that I'm ready to release right now, but we will be getting a summary out.
Okay. Camilla asks, so despite the presidential proclamation being lifted in November, U.S. consulates in Europe continue to cancel non-immigrant visa interviews for November. Any idea what we can do? We've already had our in-person interview in 2021, but we're not eligible for a national interest exception.
I don't know. I don't know whether that's consulate specific to certain consulates in Europe. If that's happening at every consulate, I'm sorry, I just don't have any more details on that.
Yeah. Okay. Here is Hani asking if we know when the last DQ person got DQ'd.
No, late September, but I don't have anything more specific than that.
Okay. And Osama is again just saying that we need to appeal, and Aaron discussed why the benefits to appeal, but also the dangers of appealing, and why the remedy that we did get was a really great remedy, even if it wasn't absolutely perfect, but it was extraordinary nonetheless. And that Hani is asking another question that we don't have the exact information for, but that was the last question. Did we have anything else that we wanted to add?
I don't think so. I guess in response to that last question from Osama saying, demanding that we appeal. I'm sorry, we can't have the whole strategy dictated by individual plaintiffs. We have to look out for plaintiffs as a whole. And when we took on this case, the retainer agreement or the engagement agreement wasn't, hey, you're going to represent us in front of the District Court of District Columbia and in appealing any order. That's just not what it said. We want the best for all our plaintiffs. We want the best for you, Osama. Believe me, we do. And we will advocate that they work to make sure that embassies, including in Egypt, are processing cases, or that they're facilitating transfers, so that everybody has a fair shot at benefiting from the reservation. But I can't promise that we're going to appeal right now.
Okay. All right. Well, with that, I guess we'll sign off.
Okay. Thank you, everybody. Thanks, Jennifer. Thanks, Ryan.
Thank you.